Subscribe to get contents via mail. Purchase shorthand journals and more.
Coming to the fourth and last point, the learned advocates for the petitioners vehemently submitted that the learned sessions judge in two of the present petitions have clearly misinterpreted the provision contained in section 36D of the Act, which pertains for institutional provisions. It was further submitted that by virtue of the session courts have been specifically invested with special powers to take cognizance and conduct the trial court under NDPS Act, and accordingly, till the time such special courts are constituted, the session courts for all practical purposes under the said Act are deemed to be the special courts, and in that view of the matter, there was no question of any accused under Act having been committed to the session court without complying with the requirements contained in section 209 of the code, making good these submissions, the learned advocates for the petitioners have invited attention of this court first of all to section 36, which speaks about constitution of the special courts by the government for the purposes of providing speedy trial of the offences under the Act, Thereafter, attention of this court was further invited to section 36A, which directs the special courts to take cognizance of the offence upon the perusal of police report without the accused being committed to it for trial. Thereafter, attention of this court was further invited to the said Act, which, as stated above, pertains to the transitional provisions, that is to say, till the same special courts are constituted under section 36 of the said Act, offences under the NDPS Act were required to be tried by the courts of session. On the basis of the above, it was further submitted that looking to the scheme of the NDPS Act and the relevant provisions under sections 36, they are indeed clear enough to indicate that the cases under the said Act are to be conducted by the special courts under section 36, and for that purpose, similarly by virtue of section 36A, the committal proceedings were dispensed with, thus, till the time special courts are constituted by the state government, session courts have been invested with the powers of special courts by virtue of section 36A, hence the question of committing the accused to the court of session clearly stands dispensed with. In support of this contention, the learned advocates for the petitioners have relied upon decision of Kerala High Court rendered in Criminal Reference Number 2, reported in 1992, drugs cases. Now, regarding the said section 36D, it is very clear that the legislature has made some transitional provision only till such time the special courts are constituted under section 36 of the NDPS Act, that is to say, by virtue of this transitional provision under section 36D, the legislature has directed that till the time special courts are constituted under section 36, the cases under NDPS Act shall be tried by the court of session, and accordingly for that purpose.